Justice Horace Gray was born into a very prominent Boston family. After brief service in the Revolutionary War, his grandfather, William Rufus Gray, rose from humble origins to become the richest man in New England, if not the entire country, heading an international mercantile business with the largest shipping fleet in the United States. In the late 1840s, the business faltered, leading Gray to cut short his European travels and return to Harvard to study law. He became one of the leading lawyers and intellectuals in Boston and was confirmed to the U.S. Supreme Court with overwhelming support. Gray's unanimous decision for the court in Columbia and Puget Sound Railroad versus Hawthorne brought federal common law into conformity with a rule that, by the end of the 19th century, most state Supreme Courts had accepted. The court held that evidence of a safety improvement made after an accident is not relevant to show that the defendant had been negligent before. The court's opinion also pointed out that such evidence has a tendency to confuse the issues and to prejudice the defendant, the same considerations that can justify excluding evidence under Rule 403. So, like the holding in Old Chief, Rule 407 can be understood as providing that a change or repair has a substantially greater tendency to confuse the jury or to unfairly prejudice the defendant than it is probative of the defendant's negligence. The evidence, however, may be admissible to show something other than negligence. The court distinguished Reedman versus Conway, a case decided by the Massachusetts Supreme Judicial Court when Justice Gray was its Chief Justice. Laura Reedman was injured walking over a wooden platform connecting the sidewalk to a building with 3 shops. She sued the building's owners, who claimed the shopkeepers, who were their tenants, were responsible for maintaining the platform. The court held that evidence that the owners repaired the platform after the plaintiff's accident was competent to show that they, not the tenants, were responsible for its upkeep. As additional support, the court noted that the Minnesota Supreme Court had observed that allowing such evidence might discourage or punish the making of improvements and repairs. When it drafted Rule 407, the advisory committee stated that this was the more impressive ground for the rule, even though under the common law, the supposed public policy was a less important reason for excluding evidence than was its potential to mislead the jury. Hawthorne shows that Rule 407 reflects a specific application of Rule 403's balancing test, just as Old Chief does, and is not the expression of any public policy. Rule 407 applies not only to repair work, but to a broad range of remedial measures taken after an alleged injury, publishing instructions or warning signs, changing policies, procedures, or protocols, revising contract language, disciplining or dismissing employees, and changing a product's design or manufacturing process. It applies only to changes made after the injury giving rise to the lawsuit. Some courts limit the rule to measures taken voluntarily by the defendant and do not exclude changes required by foreign or domestic law or modifications made by third parties. The rule preserves Hawthorne's caveat that remedial measures can be used to show ownership, control, and the feasibility of safer alternatives in cases where those are issues. Changes made to the rule in 1997 show how problematic rulemaking can become when the true purpose of a rule is not understood. In the mid-20th century, there was debate among the state and federal courts over whether Rule 407 ought to apply to product liability cases, where the issue is not negligence, but whether the product was designed or made in a reasonably safe way. Following most federal circuit courts, the advisory committee made the rule applicable in those cases. However, those federal courts had generally relied on the advisory committee's incorrect assertion that encouraging repairs as a matter of public policy was the rule's main purpose, which, as some state courts realized, it wasn't. Negligence suits are centuries old, but product liability actions are naturally about as new as mass manufacturing itself. A 1916 New York Court of Appeals opinion by then-Judge and later U.S. Supreme Court Justice Benjamin Cardozo is credited as the progenitor of the genre. As he recognized, a large-scale manufacturer needs to be held responsible for making a safe product, and the degree of care demanded varies with the danger the product poses. While Congress was revising the draft federal rules of evidence, the California Supreme Court recognized that in 20th century product liability cases, the balance between probative value and the risk of confusing the issues is struck differently than in 19th century negligence cases like Hawthorne. Justice Stanley Mosk's landmark opinion in Alt versus International Harvester also pointed out that modern mass manufacturers have every reason to improve their products, even if evidence of those improvements can be used against them. His opinion is still the law in California and has arguably been more influential on other states than the federal rule, which failed to consider the proliferation of product liability cases. The advisory committee should have considered that the probative value of a remedial change is much higher when the issue is whether a product was safe to use, as opposed to when the issue is negligence. As Hawthorne explained, after an accident, a person might take extreme measures to prevent any recurrence. That does not mean that he wasn't careful in the first place, or that the accident was not the result of the plaintiff's own carelessness. The evidence of the defendant's subsequent remedial measure is equivocal at best. In a product liability case, in contrast, the fact that the defendant made the product safer after an injury is very probative as to whether the product was originally as safe as it reasonably could have been. As Justice Cardozo explained, product manufacturers are held to a higher standard of care than ordinary negligence, particularly when failure to spot a defect would be extremely dangerous. An improved design is much more likely to mean that a large-scale manufacturer did not spend as much time, money, and effort on the original design as it should have. Like California, most states do not apply their version of Rule 407 in product liability cases. Because the advisory committee misconceived Rule 407's underlying purpose, it locked into federal law a policy of excluding highly probative evidence regarding whether corporations cut corners in designing products. This illustrates how the adversarial system's common law approach is better able to keep the law serving justice as circumstances change than the rigid written codes more typical of inquisitorial systems. If the advisory committee had understood Rule 407 correctly, it might have proposed something like Rhode Island's unique version of the rule. Rhode Island requires the judge in each case, no matter the claims, to balance the probative value of a subsequent remedial measure against the risk of confusing the jury or unfairly prejudicing the defendant. That version is true to the Hawthorne opinion and more likely to lead to accurate verdicts and just outcomes. Rules 409 and 411 restate the common law that neither an offer to pay medical bills after an accident nor the fact that a person insured against an accident is relevant to liability. They are founded as much on considerations of relevance as on any public policy to encourage empathy or responsibility. Rule 408 furthers the goal of encouraging civil litigants to settle their cases without a trial. An offer to settle a case is also not very probative on the issue of fault. It implies only a desire to be willing to pay a certain amount to be rid of the case. The rule makes discussions about settling a disputed claim inadmissible at trial. Claim here is used in its colloquial sense, not in the sense of a claim in a lawsuit. There is a claim only if the injured party has somehow asserted that she is entitled to compensation, but that assertion can be any written or oral demand. The claim must be disputed. The potential defendant has to deny either being liable or owing the amount claimed. If there is no dispute, there is nothing to settle, and any discussions between the parties can be used as evidence if a dispute arises later. Rule 410 similarly bars using statements made during plea negotiations and proceedings related to guilty pleas that are later withdrawn. A nolo contendere plea is a special plea permitted in certain cases, primarily very minor ones, in which the defendant neither admits nor denies the charges, but accepts the punishment, usually just a small fine. Rule 410 applies only to discussions with the prosecutor or someone expressly authorized to negotiate on the prosecutor's behalf. Statements to police made without the prosecutor's authorization to negotiate are not covered. This rule was meant to further a policy of encouraging the resolution of cases through candid plea discussions, but that is no longer necessary, and neither is the rule. Today's federal criminal defendants have all the incentive they need to plead guilty. In every year between 1960 and 1990, the percentage of federal defendants who pled guilty remained between about 77 and 86%. In 1987, an entirely new federal sentencing system went into effect. It was premised on making prosecutions more efficient by making them less adversarial and more inquisitorial. A key provision of the new system required that defendants who were convicted after trial be guaranteed a substantially higher sentence, usually about 40% higher, than if they had pled guilty. There was no other bargaining to be done. The trial penalty was specified in a chart whose prescribed sentence was based on the prosecution's accusations, not on the strength of the evidence. Since then, as intended, the proportion of cases decided by guilty plea has done nothing but go up, while prosecutions have exploded in number and mass incarceration has become a serious issue. There are very, very few federal criminal trials anymore because the system extorts guilty pleas by making trials in cases where there is conflicting evidence very costly for the defendant. There is a lot more to this that is deeply problematic, but for our purposes, we need only understand that there is enormous, well-documented pressure on federal defendants to plead guilty. And that is why the Supreme Court could nullify Rule 410 without any worry. The majority opinion in United States versus Mezzanatto correctly quotes the basic rule of waiver, the key phrase in it being intended for his benefit. The question the case raises is whether Rule 410 was created to benefit defendants and is therefore subject to waiver. The majority never undertakes to answer that question. Instead, it explains in Part 3B that permitting waiver serves the public policy of encouraging prosecutors to negotiate. Of course, implicit in that conception of Rule 410 is the idea that the rule is not intended for the defendant's sole benefit, and therefore should not be waivable by him. Part 3C pretends that defendants have any bargaining power in the new system of sentencing by relying on very old cases that were decided under the old system. The concurrence pretends that this case determines only whether plea negotiations can be used to impeach, when, as the dissent predicted in its final paragraph, the majority's rationale was immediately used to justify blanket waivers of Rule 410. The dissent is the only opinion to tackle the real issue, whether Rule 410 was intended to benefit criminal defendants, and begins by pointing out that waivability is not necessarily always the default rule. Justice Souter relies primarily on the advisory committee notes, to explain that Congress could not have intended Rule 410 to be waivable because it benefits the judicial system as a whole, not criminal defendants in particular. This is clearly the right analysis, which is why it is the only one that squares with the 1873 Supreme Court case that the majority itself cited and then ignored. Given the inordinate pressure that the federal sentencing guidelines are well known to exert on defendants, Mezzanatto is best understood as the court effectively repealing Rule 410 because it is no longer needed to bring defendants to the bargaining table.